Okay, we've got just a few more here, and then we'll see if we can get things wrapped up. But you know, there've been a lot of accusations back and forth about what this rule will do, what it won't do. One of the things we've heard a good deal about is that the new rule will make PSA a trial lawyer's dream. Any responses on that one?
Here's an example of a deceptive act. You have the new USDA GIPSA administrator, Dudley Butler, responding to questions from the audience. And the audience says, what can we do quickly? Because if we have to file lawsuits to seek protections under the Packers and Stockyards Act, it takes years for a case to work through court. So Mr. Butler responds and says, because the Packers and Stockyards Act has ambiguous terms like unfair, unjustly discriminatory, and deceptive, and those terms have not been defined, and the perimeters defining what's a lawful act and an unlawful act have never been established, because that's the condition that exists today, it's a lawyer's dream, a plaintiff's lawyer's dream, because of all the uncertainty. But Mr. Butler went on to say, but what we need to do today is we need to define the terms and establish the parameters so producers and the companies know the rules that they must operate under, and folks, that will limit uncertainty, which will necessarily limit the potential for litigation. What the rule does is define and clarify what the Act has prohibited all along. But because rules have never been promulgated to precisely state what is an unlawful practice, what is unfair, what is unjustly discriminatory, it was a heyday for attorneys. That's why we've had so many lawsuits in recent years. And you've heard from two from Herman. It was the Pickett versus IBP, the Schumacher versus Tyson. In the hog and poultry industry, we've had London versus Pilgrim's Pride. We've had Bean versus Oklahoma. We've had Terry versus Tyson. There's been a host of cases that have been filed precisely because USDA hasn't done what they're finally doing. And that is clarifying how the law that's been on the books for 90 years is finally going to be implemented and enforced in a manner in which it will further Congress's intent to protect producers against the monopolistic practices of the packers.
Go on. The deceptive practice that you were going to eliminate.
Oh,
I think you were going there.
Okay, I didn't finish that. So the deception was that they had taken Mr. Dudley's comments not just out of context, but they purposefully omitted the fact that he was explaining how things were today versus how they would be with the rule. And so they come up and said, even the GIPSA administrator claimed this rule is going to be a heyday for trial lawyers. That's absolutely false. And the rule expressly states that it is the intent of the rule to limit that uncertainty, to limit the potential for confusion and litigation within the industry, because again, the rules would be more clearly defined. And so the only way that that statement could be true, the only way that this rule would in fact increase litigation, is if the packers knowingly engaged in unlawful activities in retaliation and despite the rule.